Trial passage for Punjab and Haryana High Court. Exercise number 12 at the rate 100 word per minute. So be ready, start. A per usual of the above quoted order indicates that the subject matter is posting of inspector of police as in charge of inspector grade police stations. The respondent number 3 has stated that several irregularities in posting of in charge of police stations in various districts have come to light. He states that there are several posts of inspector of police lying vacant in the state and proceedings for promotion to the post of inspector of police are being undertaken by the states. He further found that in some districts there are sufficient number of inspectors of police, and even then they are not being given charge of the police stations. Consequently, he states that when the state government has upgraded the police stations to be of the grade of inspector, then charge of such police stations should be given to an inspector of police. The order expresses its doubts regarding various districts where, although inspectors of police are available, but they have not been given charge of the police station, and in their place the station officer is continuing to hold charge. It is here that learned counsel for the petitioner has contended that the direction issued by the respondent number 3 is in suppression of the government order dated 11/12/2008, in as much as when all the police stations have been upgraded to be police stations of the inspector's grade, then a sub-inspector cannot hold charge of such police station. He has further submitted that in the recitation made in the impugned order, it is clearly provided that the practice prevailing earlier should continue. The aforesaid submission requires to be tested on the provision made in the impugned order. Impugned order clearly states that there are several posts of inspectors lying vacant in the states of UP, and proceedings for promotion to the post of inspector of police are being undertaken. It also states that in some districts inspectors of police are available, but they are not being given charge of the police stations. These are two reasons given in the impugned order which necessitated the respondent number 3 to issue directions. The reason being, one, that there are several vacancies on the post of inspector of police in the state, and second, that in some districts inspectors of police have not been given charge of the police station. In the light of the aforesaid two reasons given in the impugned order, the respondent number 3 has provided that all inspector grade police stations shall be in the charge of inspector of police in those districts where inspectors of police are available. The second direction given in the impugned order is that in those police stations where sub-inspector is in charge, the sub-inspector shall continue to hold charge as was the practice earlier. This direction has to be read with reason given in their impugned order before it can be held that it is in supersession of the government order dated 11/12/2008. The impugned order clearly states that there are several posts of inspector of police lying vacant in the state of UP. Full stop.